doing it well, and they're getting big old fat income tax deductions. So quite frankly, if you're not, you're the idiot that's here, because if you've got property that you can make one of these either facade easement donations or conservation use donations on, it really is a tremendous advantage that you have. And at least through the end of this year, you also have very generous, remember, limits on the deduction. If Congress doesn't extend it, theoretically, if you do one of these donations early next year, you're stuck with a 30% AGI limitation and only a 5-year carryover. So there is incentive to act sooner rather than later. Think of it like the McRib, right? It's available now, but they tell you it's for a limited time only, and you never know when they can take it away. They always take it away in the second week of December. And it always re-debuts every September. So, not that I know this, but you know, I have it on authority that that's at least kind of the case. All right, to move along, how about to the bottom of page 9 here? One other thing that ATRA did that's slightly related, I guess, to the charitable donation context while we're here, was to revive charitable rollovers again. You'll remember how in the 2006 Act we got charitable rollovers that was put in there that says if you have reached age 70 and a half, when required minimum distributions would normally be started, you can have up to $100,000 go directly from your IRA to charity. As long as it doesn't land in one of your personal accounts, and as long as you don't personally touch the money, you don't have to take that up to $100,000 donation into gross income, but it counts against your required minimum distributions. This is awesome for our clients who are 70 and a half or older, who are sitting there saying, I don't really need the distributions from my IRA at this point, but I have to take them because of the required minimum distribution rules. How about if you don't have to include it in gross income, because it can go directly to charity instead? That's a pretty nice little technique, because remember, the alternative is you receive the $100,000, then you donate it to charity, and you think, well, that functionally gives me the same thing. Because the charitable deduction is an itemized deduction. And remember, ATRA revived the overall limitation on itemized deductions. The phase-outs of itemized deductions are back, so you're not necessarily going to get a 100% write-off, plus you have the 50% of AGI limitation that's in play. So it is much better to have the money go directly from the IRA to charity than it is to receive the funds and make the charitable donation with those funds. It's yet another advantage to reaching age 70 and a half, other than the fact that you reached age 70 and a half. By the way, Hallmark should have a happy 70 and a half birthday card, shouldn't they? Because, I mean, you know, after 21, what's there to live for? Some kids tried to tell me 25 because that's when you can rent a car. But, you know, please, you have somebody rent it for you. It's like, how did you buy beer when you were 18, for God's sakes? We got ways around that. But, you know, after 21, it's 70 and a half, and then that's it. Oh, apologies to some of you in the room. Then there's 100. Willard Scott will read your name. It's all good. Good. Question is the charitable rollover continuing? Under ATRA, it's good through the end of this year, but that's it. Theoretically, you can't do it in 2014. Now, we've seen the charitable rollover die once before and like a vampire come back to life, right? Because it had expired at the end of 2011, and we thought that was the last time you could do it. And then ATRA came back and said, nope, you could have done it in 2012. You just never knew you could. So we'll let you do it in January and pretend that you did it in 2012. And you can do it again in 2013, but that's it, says ATRA. It could die again, but it could also be extended again, who knows. But at least we know your 2013 window, if you haven't exercised it yet, it's definitely closing at the end of this year. So it's a good thing to consider for the clients, again, who don't really need the money, and they can make that charitable donation at the same time. Another ATRA provision, if we can skip over to the bottom of page 11, is in connection with so-called Section 1202 stock. You remember 1202 stock? This came to us also in the 1993 Act, the same act that first gave us the 39.6% rate. It was under the Clinton administration. The cigar was not just a cigar. You'll remember that Section 1202 is a provision that allows a taxpayer to be able to exclude, as it was first introduced, half of the gain from the sale of qualified small business stock. What's qualified small business stock? It's stock in a qualified small business. Thank you. Qualified small business is a domestic C corporation. You can't do this with S stock. It is stock in a domestic C corporation that is engaged in an active trade or business. It is not engaged in most of your white-collar service businesses, so it doesn't apply in the white-collar services industry, but outside of that, typically it does. You cannot have more than $50 million of gross assets in the corporation. And you have to have at least 80% of the corporation's assets being used toward the conduct of that active trade or business. There's a few other little requirements, like the stock has to have been acquired in exchange for property or services and not acquired by gift, but there is a special little exception for people that are getting the stock from founders and all of that. And there's a few other little nuanced technical requirements, but with a broad brush, that's qualified small business stock, stock in a small C corporation. When it was first introduced, you got to exclude half of the gain from the sale of that qualified small business stock, which sounded like a great deal. But then you went back over and you read Section 1H, the capital gains rules, and you saw this rather little unpleasant addition that said, you know how we have the 20% rate, forget the 3.8% for a second, you know how we have the 20% rate generally, but we have the 25% rate for depreciation recapture on buildings, and we have the 28% rate for collectibles gain that's in play. You remember those less preferential rates? Well, the statute also provides that your included half of 1202 stock is taxed as a collectible. It is taxed at a 28% rate. So of course, if I've got half the gain being excluded and the other half being taxed at 28%, I'm paying a 14% tax on the gain from the sale of that stock. I like how I see so many heads that are nodding right now because you get that. Because when I have to teach that at law school, that takes 30 minutes. Right? One half is at 0 and the other half is at 28. The whole thing's at 14. No way! We'll do it with like colored ping pong balls. Like 28% of these ping pong balls are painted. None of these are. Let's blend them all together. 1%. Wow! Shaman! You know, they say as I do these mathematical tricks, right? But this group is savvy enough. 14%. Well, we just got out of a world in which the capital gains rate was 15%. So you're telling me that the headache of being a C corporation, that I got to hold the stock for at least 5 years, not just more than 1 year, and I have to have these gross asset limitations, I have to have this active trade or business limitation, I got to comply with all these requirements to save 1% of gain on the back end? No, thank you. It just wasn't all that sexy, and so you weren't people, you know, whenever you went to a choice of entity presentation, nobody was saying, hey, think about a C corporation because it can be a qualified small business. Everybody was like, forget about it, right? Well, lately, since the Obama administration, we've been goosing up this exclusion, and I don't think the exclusion can get any better than this, because now you get a 100% exclusion on the gain of qualified small business stock. And even my students get that that's a 0% effective rate that I am paying on the whole thing, which beats a 23.8% margin, you know, by quite a margin, right, as far as tax rates are concerned. So there starts to look like a real benefit. And when you think about this now, if you're an entrepreneur and you're going to be starting up a new business and you want to attract outside capital, is it so bad that you are a C corporation for your first several years of operation? You know, there's always the argument to be made that sometimes in terms of total tax paid, you're going to pay less tax in your early years as a C corporation if you're not distributing dividends. What profits are you going to have in the first 5 years anyway, really? You're not going to be, and any of your profits are just going to be going back into the business. If you're not going to be making dividend distributions anyway, the Section 11 rates are lower than the individual rates under Section 1 on most forms of corporate income. And so why not go ahead and be a C corporation? Because you can go to an investor and say, hey, invest in my business. If my business works, in 5 years or in 6 years when you sell the stock, you're not going to pay any tax on the gain. Whereas if you go invest in this traditional business over here that's not a qualified small business, they're going to have to generate a higher rate of return to compensate for the 23.8% capital gains tax that you're going to have to pay upon a sale of the corporation. So you actually ease the internal rate of return that you have to generate to become an attractive investment to outside investors. Angels are going to take a little bit more of a gamble on you because they've got a nice 0% tax rate at the finish line as opposed to a 23.8% tax rate that's out there. That can actually be something that's really helpful. This comes to an end at the end of this year. We go back, starting in 2014, to excluding half of the gain. Now, it's important that you understand on this 1202 limitation, we are talking about the 100% exclusion applying to stock purchased now. You still have to hold the stock for more than 5 years before you can sell it and get the 0% rate. That doesn't change. But we're talking not about stock that is sold today, we're talking about stock purchased today. This is for entrepreneurs today to go take to potential investors and say, in 5 years you can sell this and have zero tax. And at first, some people were thinking, well, wait a minute, this isn't about economic stimulus today, that's about economic stimulus in 5 years. And the ads always tell me if my stimulus lasts for more than 4 hours, I'm supposed to see a doctor. I'm not so sure I really care about stimulus in 5 years, right? But it is about stimulus now because of the ability to go and approach those investors and say, hey, look, you've got this neat opportunity to invest in us now. That's what it's all about. And it is coming to an end at the end of this year. The odds of revival for it, since this was only extended a year, we've only had this 100% exclusion in place for a couple of years now. Maybe it could last a little bit longer, but again, if you're subscribing to the general theory that the worst days of the Great Recession are behind us, more and more of these provisions that are simply about economic stimulus and not at all about tax policy start to become early candidates for being completely repealed. Another one, which, boy, talk about having absolutely no purpose at all. Top of page 12. Here's another one that's just an amazing provision. Charitable contributions by S corporations, right? This is unreal. We've had, again, this rule since 2006, but it has died not once but twice and has come back, and it's in play for this year once again, even though it had been dead for all of 2012. This is a rule that says, for example, I have a S corporation, let's say I'm the sole shareholder of an S corporation that owns Blackacre, a parcel of undeveloped real estate. Let's say that Blackacre has a fair market value of $100,000 and has an adjusted basis to the S corporation of $10,000. If the S corporation makes a charitable contribution of Blackacre to an organization, what happens? Well, the deduction for the corporation flows through to the shareholder, me, and I get to throw that deduction onto my return as if I had made it. Now, because that's long-term capital gain property in the hands of the corporation, I get a fair market value deduction. Woohoo! I get a $100,000 deduction for the donation made by my S corporation. But now, when you first learned about S corporations, you learned that when a $100,000 deduction passes through from the corporation, you're going to have to reduce your stock basis by $100,000, right? Because your stock basis in an S corporation tracks how much you can pull out in the form of tax benefits or distributions from the corporation tax-free. So you would normally say, yeah, I got to reduce my basis by $100,000, but that makes sense because I got a $100,000 deduction that came to me. That could be something of a problem because in the closely held context especially, sometimes shareholders don't have a whole lot of basis in their stock. And of course, if I only had a $60,000 basis in my stock, I can only take $60,000 of the deduction this year, and then the remaining $40,000 would be suspended until a later year in which I have sufficient basis to be able to claim the deduction, right? That's how we always knew the rules to work. It made sense. It had an intuitive logic to it. It was perfectly appropriate. Then in 2006, we introduced this little innocuous rule that says when you're making stock basis adjustments, you only reduce stock basis by the adjusted basis of property that is donated by the S corporation to charity. In the case of charitable contributions of property by an S corporation, you reduce stock basis by the adjusted basis of the contributed property. So now, as a result of that innocuous little rule that has been revived for 2013, if my S corporation makes that same donation of Blackacre, I get a $100,000 deduction, but I only have to reduce my stock basis by $10,000. I only have to have $10,000 of stock basis to be able to take a $100,000 deduction. Wow! Yeah, sign me up for that. That is awesome. A $100,000 deduction at a cost of only $10,000 worth of basis. I will donate everything I possibly can. I'm taking my S corporation to the Goodwill in the back of my van right now and seeing how much I can get for this thing if I'm getting a donation that's quite like that. That is amazing. You want to know where it's really amazing? It's really amazing for S corporations that recently became an S corporation. You know, they used to have a checkered past as a C corporation, and now they've seen the light and they've converted. They are a born-again corporation, but now they're S instead of C, the way that they should have been all the way along. Well, remember how for the first few years that when you switch from C to S, if you dispose of any of your old subchapter C assets, you still have to pay the built-in gains tax under section 1374, and that built-in gains tax is a corporate level tax equal to 35% of the gains that are attributable to your subchapter C years. So using my example, if Blackacre had been held by the corporation back in its subchapter C years, and all of that $90,000 of appreciation from 10,000 basis to $100,000 value happened during the subchapter C years. If I now make an S corporation election, I wouldn't do it now, if I made it last year so that it was effective for this year, and then this year had the S corporation make the charitable donation of property, not only am I getting the fair market value deduction at a cost of reducing my stock basis by only $10,000, but I'm also paying no 1374 tax. Why? The 1374 tax, by definition, only applies to recognized built-in gains, and charitable donations don't give rise to recognized gains. So I can avoid's not right, I can plan against the 1374 tax. By the way, is there anybody here from the Internal Revenue Service? Okay, I can avoid the 1374 tax entirely. I get the fair market value deduction, and I'm only having to reduce my stock basis by the $10,000. Win, win, win. Charlie Sheen is jealous of me here, right? Because I am doing so much winning. This is just fantastic. What's the tax policy rationale behind it? There isn't one. This went into the code because there was a particular member of Congress who happened to be a shareholder in an S corporation that had a whole lot of ranch land in Montana. They were going to do a charitable donation of the land, but they didn't have enough basis to be able to deduct it all in the year of purchase. So they inserted that rule and said, here, you got 2 years to make the donation. And it's just been one of those little stickler rules that because no one really talks about it much, the estimated revenue loss isn't all that significant. And granted, it's not like we sit here and have 40 clients for whom we can implement this strategy when we go back to our office this afternoon, assuming you skip out on the debtor-creditor session this afternoon. Instead, I mean, it's only going to apply for those clients who happen to have the S corporation with either the built-in gain property or the capital asset, and you're thinking about making a charitable donation anyway. Hey, I want to make it now. I don't want to make it next year because I can't be certain that that particular provision is going to be around at that time. Okay. We can turn over to at the bottom of page 12 now. We start to get into the estate and gift portions of the Internal Revenue Code. And there's a few cases of significance that I think are kind of worth talking about here. I'm going to direct our attention already to the bottom of page 14 because let's just face it, it's not every time that an estate tax marital deduction case makes the front page of the New York Times, the Washington Post, USA Today, and every major media outlet, like what had happened in June of this year when the Supreme Court reached its opinion in Windsor versus United States, right? You'll remember that this was the case that involved Edie and Taya, a New York couple. These women had lived in New York for a long time. They had been in a committed relationship, as you see there, with each other since the 1960s. They finally go across the border to Canada to get married in 2007. And they come back to New York. It was just a weekend retreat in Canada. And hey, when you're in Canada, don't you always find romance just gets the best of you in Canada? And you can't help it, and before you know it, you're doing a quickie little ceremony there. Well, Canada has no problem with same-sex marriages. Hell, you can marry a moose if you're willing to pay for a marriage license up in Canada, so they're fine with it. They have no hang-up. So they say, all right, come on, get married here. They go back to New York. They live in New York. When you see that Taya then dies in 2009, by the time that Taya had died, New York, at least New York did not yet have same-sex marriages at that time, but they said that they would recognize same-sex marriages that were validly performed in other jurisdictions. So for New York state purposes, in effect, Edie and Taya were married. But, of course, for federal tax purposes, the Defense of Marriage Act had provided that for all purposes of federal law, the definition of marriage and spouse and husband and wife is limited only to couples where it is one man and one woman. The original version of the statute, by the way, just said man and woman, and then people were like, yeah, but what about Utah? So then they said, all right, one man and one woman, so as to make it clear, that's what we mean by marriage, right? The old-fashioned way, supposedly. So that's what DOMA had done, and of course, they couldn't claim an estate tax marital deduction for federal tax purposes like they could for New York estate tax purposes. So Edie brings a lawsuit saying, I'm going to challenge the constitutionality of that. Had you been counsel to Edie at that particular point, you would have been reluctant to take the case on a contingent fee basis, right? Because you're kind of thinking, you know, it's pretty well established, you know, federal supremacy clause, all this, the federal government doesn't have to respect states' rights and all this stuff on everything. Just because the state says they're married doesn't mean they have to be married for federal purposes. You have a congressional statute that pretty directly says, no, you can't. You hadn't yet had any case law that had indicated that discrimination on the basis of sexual orientation was a full-on suspect classification. You had quasi-suspect classifications and all that stuff that had been percolating, but you didn't really have any kind of firm authority that you could go in and say, this is quite clearly unconstitutional. But nonetheless, seeking a refund of the over $250,000 in federal estate tax that was owed, the case goes along. It goes to the district court. Federal district court grants summary judgment to Edie as executor of Taya's estate on the grounds that even if you use the old weak limp noodle rational basis test, there was no rational basis for DOMA to exist. It was not serving even reasonably related to any legitimate state interest, because even if you said that there was a legitimate state interest in preserving the sanctity of marriage, which was DOMA's intent, the lower court had just said, we don't even see how restricting marriage to one man and one woman fulfills the institution of marriage, because there's a lot of crappy marriages out there between one man and one woman. And there's a lot of really good marriages out there between man and woman and woman. So we don't see how drawing the line just on the basis of sexual orientation furthers that purpose. It's struck down no matter what level of scrutiny that you use. Goes up to the Second Circuit Court of Appeals, and the Second Circuit Court of Appeals, in a divided opinion, says, well, we think it's not just the rational basis test. We think that for things like discrimination on the basis of sexual orientation, that you should be using intermediate scrutiny and not just the rational basis test, because rational basis test, let's face it, is pretty easy to meet. The Second Circuit, by announcing a higher level of scrutiny, it's then no surprise that they say this doesn't survive a higher level of scrutiny. Heck, the lower court said it didn't even survive the weakest form of scrutiny. So not surviving a higher level, then it makes sense. But it goes up to the Supreme Court, and as we all know, in June of this year, in a 5-4 decision authored by Justice Kennedy for the majority, the Supreme Court says that Section 3 of the Defense of Marriage Act is unconstitutional. They did not pick a standard of review. They didn't say that from now on sexual orientation is subject to intermediate scrutiny or strict scrutiny or rational basis or anything. Instead, Justice Kennedy uses the language that it represents a deprivation of liberty under the Fifth Amendment. He never uses the word due process in his opinion, but it almost sounds like he's framing this as a substantive due process issue. The other thing that Justice Kennedy talks about in his opinion is the fact that historically states have defined marriage. And historically, the federal government has allowed states to define marriage for themselves. And the majority concludes that when you then have a federal law that provides a federal definition of marriage, you are disrespecting states' rights. So on this sort of quasi-federalism, quasi-states' rights grounds, the majority ends up saying that states are free to be able to define marriage for themselves. The Windsor case doesn't say that there is a constitutional right to marriage that is available to same-sex couples the same way that it is to different-sex couples. It is not a case that establishes, again, a higher level of scrutiny. It just simply says states can define marriage as they want, and the federal government has to respect any state-sanctioned marriage. If it's approved by the state, then it needs to be approved by the feds. All right, then. That left us with some questions, though, about how exactly is this supposed to be implemented. If we know that Edie and Taya for New York, it's simple because New York now has same-sex marriage even by ceremony in the state of New York. They recognize same-sex marriage, not just those performed outside, but even those performed within New York. It's easy for the New York couple because now they're married for federal tax purposes and they're married for state purposes. But what do we do about the same-sex couple here in South Dakota, where they can't be recognized as married for state law purposes? Does that mean that their marriage is not recognized? If they have a marriage, is it not recognized for federal tax purposes? Does it matter where they married? How is all this supposed to be implemented? Page 18 of the materials tells you about, the very end here, this one under section 7701, is discussion of the revenue ruling from a couple of weeks ago, revenue ruling 2013-17. And in 2013-17, the service made 3 rulings. They said, number 1, from the effective date of this ruling, and by the way, the effective date of the ruling was Monday of this week. So as of Monday of this week, said this ruling back in late August, any reference in the Internal Revenue Code that talks about spouses, that talks about married couples, that talks about husband and wife, that term now expressly includes same-sex couples who were lawfully married under state law. Well, duh, the Windsor case already told us that they have to respect any state-sanctioned marriage. So that's not a surprising ruling. Ruling number 2 that's contained in the revenue ruling is that those individuals that are living in states that recognize a legal non-marital relationship, like, for example, domestic partnerships or civil unions, members of a domestic partnership and members of a civil union are not considered married for federal tax purposes if they're not considered married in their state. And in most, of course, in all the states that have, well, actually that's not true. There is a couple of states where you can be either a domestic partner or a married couple because now they've allowed same-sex marriage and so you can choose. But in a lot of states, you can be a domestic partner or you can be a member of a civil union, but the state statute will then say, but you can't be married. You can be married like, but you can't be married. The revenue ruling says if you're only married like, you're not married for purposes of the Internal Revenue Code for federal tax purposes. Well, again, duh, that's not really that complicated. I think everybody knew that. It's the third ruling that makes the difference. Because in the third ruling, the service says, what are we going to do about the couple that lives in South Dakota? But they go spend a weekend up in Canada, they go spend a weekend in New York, they go spend a weekend in Seattle, they go spend a weekend in California, and they get married there and come back to South Dakota. What are they for federal tax purposes? Treasury had to choose between a site of the ceremony rule or a domicile rule that would say, well, since South Dakota wouldn't recognize it, you're not married, or does it matter where the state where the ceremony was performed? And if you were validly married there, you're validly married for federal tax purposes. How do you answer that question? Well, you think, well, that starts to get kind of really political and everything. The service just said, hey, look, there's this old revenue ruling from the 1950s. There's a revenue ruling from the 1950s that says in those individuals who were in a common law marriage, remember how states used to allow common law marriages? So few do now, but a number of states